I'll occasionally have clients come to me and say, I want to disinherit my child, but I don't want to include them in the will. And that's a problem. So if you omit a child in the will, MGL 190B section 2-302 actually protects them. It says that if a child's forgotten, they're supposed to be included and they'll actually get a share of the estate. And so what a lot of my clients are trying to do is to preserve that child's feelings, not include them in the will, but at the same time, they're basically guaranteeing a probate fight. And they're also guaranteeing that their child would probably be successful in getting a share of the estate. So the proper thing to do is to say, I intentionally disinherit this person, and they are not to receive any assets under my will. Might sting, and we can alleviate a little bit of that by preparing a letter that the client can sign and include it with their estate planning documents to explain the reasons. But it's the better thing to do if we want to try and avoid long, protracted battles. I'll often have clients also ask me, well, should I leave them something? And then that way they're less likely to challenge. And that could be true in a will because they're going to be given notice anyway. We call this a poison pill when we pair it with a no contest clause, where if the person challenges and loses, they get nothing under the will. But in the case of a trust, it actually poses a bigger problem because now they're a beneficiary. So even if you left them a small gift of $1,000, they now are really involved in a lot of the same processes that the main beneficiaries are going to be involved with, and they can cause a lot of problems for the trustees. So the best thing to do is to be explicit, be firm, understanding that this is going to hurt, but you can provide some additional information to the children in the form of a letter. And my recommendation is always to be clear now and avoid drama in the future.